Okay, continuation. Check lang. Okay, let us proceed now dun sa second mode of extinguishment. Okay, continuation. Ito yung loss of determinating. Di ba nakalagay doon sa batas is loss of the thing due. Pero dapat it must be considered as loss of determinating. Kasi pag ang object ay indeterminate or generic thing, hindi siya magkakos ng extinguishment based on the doctrine of genus non comparative. Okay, now what are the kind of laws? Pwede siyang physical loss, legal loss, or civil loss. Kasi under the law, di ba sabi doon, when a thing is lost. A thing is lost when it perishes. Yan yung physical loss. Second, it goes out of commerce. Yan yung legal loss. Or when the thing disappear, whose existence is unknown or it cannot be recovered. Yan yung lumalabas na civil loss. Tulad ng physical loss, the house burned into ashes. Yung legal loss naman, yung dating object na legal, subsequently declared to become unlawful na. Civil loss, yun nga, when the thing disappear in a such way that its existence is unknown and it cannot be covered. Halimbawa, tinapon mo yung singsing sa gitna ng Pacific Ocean, o kaya na-rob sa'yo, nakuha yung object by using force or intimidation at di na makita, then that is now considered as civil loss. Okay, now, dun sa loss, pwede kasi itong total or pwedeng partial. Okay, pag obligation to give a determinating. Ngayon, pag total loss yan through the fault ng debtor, okay, the debtor is liable for damages. Pero pag na-loss yung determinate object without fault ng debtor, edi lumalabas by fortuitous event, extinguished. Pero meron tayong exception, di ba? Law. Second is stipulation. Saka nature ng obligation requires the assumption of risk. Now, under law, pag may legal delay na, second, nag-promise kang i-deliver yung same object sa different person, okay, would not have the same interest. Okay? Pangatlo, generic thing kasi mag-apply yung doctrine of genus non comperet. And another is civil obligation arising from a criminal offense. Kasi di ba sa Article 104 ng Revised Penal Code, meron tayong meron tayong tatlong civil liability, restitution, reparation, saka indemnification for consequential damages. Okay, stipulation, and of course, nature ng obligation requires the assumption of risk. Now, sa partial loss naman, okay, kasi merong authorized ang court dito na i-declared yung partial loss as total loss depending on the circumstances of each particular case. Tulad nito, halimbawa, ang obligation ng debtor kay creditor mag-deliver ng specific race force. Pero due to the fault ng debtor, naputol yung isang paanong kabayo. In that case, pwede siyang i-treat as total loss. Why? Isang paa lang naman. Kasi racehorse siya. Pero kung i-slaughter lang yung kabayo, kahit maputol yung 3 or 4 na paa niyan, okay, then iti-treat pa rin yan as partial loss. Kaya nakadepende yan dun sa fact of each particular case. Okay, sa obligation to do naman, the debtor in obligation to do shall also be released daw when the prestation becomes legally or physically impossible without the fault of the obligor. Now, by the way, pag merong class na impossibility, okay, ng obligation to do at the beginning, void siya. Pero pag physically possible yan, from the beginning, pero subsequently naging impossible yung obligation to do, lumalabas mode of extinguishment lang siya. Now, kind of impossibility, pwedeng physical impossibility, like accident or death. Bawa, obligation to do. Namatay ang debtor, obligation ng debtor extinguished. Kasi hindi naman yan matatransmit sa legal heirs. Now, legal impossibility, example nito is ordinance declaring a residential zone. Ang problema kung obligation mo mag-construct ng commercial property or commercial building and dineclared na yan as residential area, hindi ka na pwedeng mag-construct ng commercial building. Or another example, yung lawyer is representing his client in court. Okay? Then subsequently, the lawyer was appointed as RTC judge or justice ng Court of Appeal or justice ng Supreme Court. Then hindi na siya pwedeng mag-represent ng client in court. That's why the obligation of the lawyer to his client is now extinguished. Okay, because of legal impossibility. Okay, presumption. Okay, ito laging tanong to. Article 1265. Sabi dyan, when a thing is lost in the possession of the debtor, it is presumed that it was lost though through his fault. Exception, earthquake, flood, storm, or other natural calamity. Example, I am the debtor, you're the creditor. My obligation to you is to deliver a specific horse today. Hindi ako nag-deliver today. After 1 week, yung specific horse na lost. Okay, is the debtor liable for damages? The answer is yes. Kasi wala naman akong binanggit na yung okay horse ay na-lost by fortuitous event. Hindi rin issue dito ang legal delay because there is no demand. Okay? No demand, no legal delay. Pero ang problema, wala akong binanggit na yung determinate object na lost by fortuitous event. Kaya binanggit ko lang na lost. In that case, may presumption under 1265 na yung object ay na-lost through the fault ng debtor. Kaya ibig sabihin, kung ikaw yung debtor, hawak-hawak mo yung object, biglang nawala, ang presumption ng batas, nawala yan through the fault ng debtor. Mawawala lang yung presumption na to pag ang object ay na-lost because of earthquake, flood, storm, or other natural calamity, meaning by a fortuitous event. Kaya tingnan yung maigi sa problem yan. Kung walang binanggit na na-lost by fortuitous event, mag-a-apply yung presumption under 1265 of the Civil Code. Okay, ito na tanong na rin sa board exam. The obligation daw having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third person by reason of the loss. Example, the debtor bind himself to deliver to the creditor a specific or determinate object. Ang problema, yung determinate object na lost to through the fault ng third person. Okay, ang question sa board exam dati dito, which of the following statement is not correct? Okay? Wait lang, may tumataang trend. Isip na trend ko. Okay. Balikan ko illustration na. This is the debtor, this is a creditor. Obligation to deliver the terminating, pero na-loss ito through the fault ng third person. Ang question, which of the following statement is not correct? Number 1, the obligation of the debtor to the creditor to deliver a terminating is now extinguished by loss of the thing due. That is true. Okay? Kasi nga, wala namang fault yung debtor. Pangalawa, the debtor is no longer liable to the creditor for the equivalent value of the thing. That is also true. Kasi since yung object na lost without fault ng debtor, hindi siya co-convert into monetary obligation for damages. Number 3, si creditor daw pwedeng mag-file ng case against third person para ma-recover yung value ng thing. That is true. Ito na yun. The creditor shall have all the right of action which the debtor may have against third person by reason of the loss. And letter D, si debtor daw pwedeng mag-file ng case against third person para ma-recover yung value ng thing. That is false. Ang reason dito is double benefit. Okay, bakit double benefit? Kasi ang first benefit sa part ng debtor is yung kanyang obligation na mag-deliver ng determinate object kay creditor is now extinguished by loss of the thing due. Tapos second benefit mo, magre-recover ka ng value sa third person. Binigay na kay creditor yan pursuant to 1269 of the Civil Code. Okay, next, punta tayo sa condonation. Okay, ito yung Article 1270 naman. Sabi diyan, condonation or remission daw is essentially gratuitous. Okay, kaya lumalabas, donation ang treatment diyan. And it requires the acceptance by the obligor. Kasi di ba in donation, sabi natin, no person shall be compelled to accept the generosity of another. Kaya sa donation, kailangan may acceptance ng donee. Now, since ang nature ng condonation remission of debt is like donation, kailangan may acceptance ng debtor, obligor. Sabi dyan, it may be made expressly or impliedly. Pag express, pwede itong oral or in writing. Ang writing pwedeng private, pwedeng public instrument, or implied, it can be inferred from the act. Pero take note, pag express kasi, kailangan nyo mag-comply ng form of donation. Di ba under Article 748 ng Civil Code, sabi doon, donation can either be oral or in writing. Pero oral donation requires simultaneous delivery ng things. Second paragraph, donation of movable property where the value exceed 5,000 pesos. The donation as well as the acceptance must be in writing, even a private one. In Article 749 naman, donation of immovable property regardless of value. The donation as well as the acceptance must be in a public instrument, otherwise the donation is void. Take note that donation as well as the acceptance must be in a public instrument. Kasi baka mamaya, nag-donate ako in a public instrument, pero in-accept mo in a separate paper, which is a private writing, void siya. Pero kung in-accept mo on the same public instrument, valid yun. Kaya dapat both the donation and the acceptance must be in a public instrument. Otherwise, the donation is void. Okay, pero required lang kayo mag-comply ng form of donation kung express condonation. Kasi pag implied, hindi. Ano ba example ng implied condonation? Sabi doon, voluntary delivery ng private document evidencing credit made by creditor in favor of the debtor. Kasi halimbawa, yung debtor nag-issue ng promissory note kay creditor. Yung creditor voluntary ni return yung promissory note sa debtor o implied condonation of debt yan. Hindi kayo kailangan mag-comply ng form of donation. Sabi dyan, one and the other kind shall be subject to the rules which govern inofficious donation. Ano bang ibig sabihin ng inofficious? Excessive. Okay, ang rule kasi ganito. Hindi mo pwedeng i-donate lahat ng properties mo to the extent na walang maiiwan or matitira sa'yo. Kumbaga, hindi mo pwedeng ibigay lahat-lahat. Kailangan mag-reserve ka rin ng okay para sa'yo, okay, para mag-exist ka pa rin. Okay, means of existence. Okay, kaya kung nagkaroon ka ng sobra-sobrang donation, pwede kang mag-file ng petition for reduction on the ground of inofficious donation. Kasi sobre, excessive. Okay, parang ganon din dito. Pag sobra-sobra ang pinatawad mong utang, subject din yan sa rules ng inofficious donation. Kasi yung condonation is like donation. Kaya kung sobra-sobra yung nakondon mo, you can file a petition for reduction on the ground of inofficious donation. Okay, now kind of remission as to extent, pwede raw siyang complete or pwede siyang partial. Okay, example ng complete, okay, your obligation is 10,000, I condone the entire 10,000, that is complete. Partial naman, not covered the entire obligation. Your obligation is 10,000, I condone only 8,000, that is a partial condonation. As to form, pwedeng express or implied. Sabi ko nga, pag express, pwedeng oral or in writing. Ang writing, pwedeng private, pwedeng public instrument. Or pwede rin siyang implied, it can be inferred from the conduct. Example ng implied condonation of debt is voluntary delivery ng private document evidencing credit by creditor to the debtor. Kaya once na ang creditor binalik or sinurrender yung promissory note na inisyu ng debtor voluntary, magkakaroon ng implied condonation of debt. Date of effectivity, pwede raw siyang inter vivos or mortis causa. Pag inter vivos, it takes effect during lifetime of the donor. Pag mortis causa, magtutok effect siya upon death ng donor. Pero may question ako dito. Ano ba yung dividing factor between inter vivos and mortis causa? Kasi madaling sabihin na pag inter vivos during lifetime, pag mortis causa, upon death. Okay, pero ang problema, may mga instances na nagdi-dispose ka ng property during lifetime but in the nature of a testamentary disposition. Kaya ano ba talaga yung dividing line between inter vivos and mortis causa? Paki-check nyo yung characteristic ng inter vivos and mortis causa. Kasi one of the characteristic of inter vivos is, okay, these are irrevocable transfer. Once na nag-donate ka at in-accept na ng donee ito at na-comply lahat ng form prescribed by law, ang rule is that you cannot revoke a donation. Okay, unless nag-fall yan na pwede kang mag-revoke on the ground of act of ingratitude. Okay, pero ang characteristic ng mortis causa kasi is revocable siya anytime during lifetime. Kaya nga pag binasa niyo yung tax code, di ba, pag revocable transfer yan, ibig sabihin, revocable transfer yan, ang nature niyan, testamentary disposition kasi pwede mo siyang i-revoke at any time. Okay? O kaya nag-transfer ka ng property during lifetime pero meron kang reservation either sa fruits, okay, interest niya, okay, fruits ng property, o kaya yung naked title niya, ng intention mo i-transfer lang ang full ownership upon death. That is in the nature of a testamentary disposition. Kaya that is a mortis causa transfer. Kaya itong inter vivos, irrevocable siya. Itong mortis causa is revocable at any time during lifetime. Okay, now, punta tayo dito sa illustration. Sabi dyan, the delivery of private document evidencing credit made voluntarily daw by creditor to the debtor implies the renunciation of the action which the former had against the latter. Okay? Now, example yung debtor nag-issue ng promissory note in favor of the creditor. At yung creditor, voluntary ni-return ang TN dito. O ang tawag dyan, implied condonation of debt. At merong presumption under 1272 na whenever a private document evidencing credit is now found in the possession of the debtor, it is presumed that it was voluntarily delivered by the creditor. Kaya impliedly condoned siya. Pero take note, yung presumption under 1272 is merely rebuttable. Kasi pwedeng mag-present ang creditor ng evidence na walang voluntary delivery. O example, halimbawa, yung PN later on hawak na ng debtor. Di ang presumption ng batas, voluntary na return ng creditor. Pero sabi ng creditor, hindi totoo yan kasi ito raw ang nangyari. Nung nag-mature daw yung promissory note, ang creditor pumunta sa debtor para i-present yung PN. Nung present niya yung promissory note sa debtor, ang ginawa daw ng debtor, biglang hinablot yung PN. Sabay takbo, papasok ng bahay at pinakawalan ang 10 Doberman. Kaya tumakbo yung creditor. Kaya sino may hawak ngayon ng promissory note? Yung debtor na. Pero walang voluntary delivery at na-prove kunwari ng creditor. Kaya lumalabas, okay, rebuttable ang 1272. Now, question. Okay, what do you mean by 1271 second paragraph? Sabi dito, if in order to nullify this waiver, it should be claimed to be inofficious, the debtor and his heirs may uphold it by proving that the delivery of the document was made in virtue of payment of the debt. O, ganito yan ha. Debtor, creditor, nag-issue ka ng PN. Later on yung PN, hawak na ng debtor. Sabi natin, ang presumption, it was voluntarily delivered by the creditor. Kaya implied condonation of debt. Ang problema, yung creditor nag-raise na inofficious daw to. Excessive. Ibig sabihin, pag na-prove ng creditor na may excessive condonation, pwede siyang mag-file ng petition for reduction on the ground of inofficious donation. Ano naman ang defense ng debtor pag sinasabi nitong inofficious? Ang defense mo, payment. Kasi ganito yan. Bakit ba hawak na ng debtor yung promissory note after issue? There are two possible explanations. Number one, voluntary return ng creditor, the implied condonation of debt. At pangalawa, binayaran ng debtor. Kasi kung binayaran ng creditor, the creditor must surrender the promissory note. Kaya kung sinasabi ng creditor na merong implied condonation of debt at ito ay inofficious, ang defense ng debtor dito, payment. Kasi once na-prove ng debtor na may payment, hindi ka pwedeng mag-file ng petition for reduction on the ground of inofficious donation. Okay, next. Okay, sabi ng 1273, the renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. Just follow the doctrine of accessory follows the principal. Example lang. Halimbawa, yung debtor, liable kay creditor ng 1 million. Okay, to secure the loan, nag-execute ang debtor ng real estate mortgage. Dalawang kontrakto. Yung principal contract of loan na 1 million, tapos may real estate mortgage, yung pangalawang contract. Accessory contract. Pag yung creditor, kinondon yung real estate mortgage, anong effect? Extinguish yung real estate mortgage but not the principal obligation. Because the nullity of the accessory does not follow the nullity or extinguishment of the principal obligation. Pero yung creditor, kinondon yung 1 million na principal loan, extinguish yung principal loan, extinguish din yung accessory contract of real estate mortgage. Because the extinguishment of the principal follow the extinguishment of the accessory. Ngayon, itong Article 1274, ito yung tinatawag nating implied condonation of accessory. Kanina ang pinag-usapan natin dito, implied condonation of principal. Ito, implied condonation of accessory. O, example, debtor borrow from the creditor 100,000. Kaya may principal contract of loan na 100,000. Para i-secure yung loan, yung debtor, pledge niya kay creditor yung ring. Kaya ang tawag dito, debtor pledger, ang tawag dito ay creditor pledging. Now, take note in a contract of pledge, ang dapat may hawak ng object must be creditor pledgee or third person by common agreement. Ang problema, later on, itong sing-sing, hawak na ng debtor pledger. Anong effect? The pledge is extinguished. But not the principal. Because the extinguishment of the accessory does not follow the extinguishment of the principal obligation. Question. Okay, paano kung nagkaroon ng stipulation between debtor, creditor, pledger, pledgee na even yung sing-sing ay hawak na nito? Okay, or ni-return niya rito, existing pa rin yung pledge. Ang question, is the stipulation valid? The answer is no. Void siya. Kasi pag binasa mo yung law on pledge, di ba, ang sabi ng batas, ang dapat may hawak ng object ng pledge must be creditor, pledgee, or third person by common agreement. Because any contract stipulation is void. Kaya lumalabas, basta ito hawak na ng debtor pledger, ang effect, extinguish yung pledge. Yan yung 1274. Sabi niya na, it is presumed that the accessory obligation of pledge has been remitted when the thing pledged after its delivery to the creditor is found in the possession of debtor or third person who owns the thing. Kaya once na yung object ng pledge nakabalik na yan sa pledger or owner ng thing, pledge is extinguished. Okay, next, mode of extinguishment, yung tinatawag nating merger or confusion of right. Okay, definition class ng merger. Sabi dyan, when the character of creditor and debtor are merged on the same person, magkakaroon tayo ng merger or confusion of right. Okay, 1276, merger which takes place in person of principal, debtor, creditor, benefit the guarantor. Confusion which takes place in the possession of any of the latter does not extinguish the obligation. Ano ibig sabihin yan? Example. Si A nag-issue ng promissory note payable kay B wherein G, ito yung guarantor. Si B ang ginawa, inassign yung PN kay C, inassign kay D. And D assign back to A. Sabi kasi ng batas, pag yung obligation daw ay nag-merge sa principal debtor, principal debtor, magbe-benefit yung guarantor. Kasi pag nag-merge yung obligation dito kay A, the principal obligation extinguished, it follows that the accessory contract of guarantee is likewise extinguished. Pero kung halimbawa, A to B, then B to C, then C to D, bumalik or nag-merge siya, hindi kay A, but rather sa guarantor. It will benefit only him. That's why only the contract of guarantee is extinguished, but not the principal obligation. Okay, now punta tayo dito sa merger confusion of right ng joint debtor. Sabi ng Article 1277, confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concur. Example, A, B, C are joint debtors. They issue the promissory note payable kay D for 90. Si D ang ginawa, inassign kay E, then E assign back to C. Ang problema, since A, B, C are joint, C cannot represent A and B. Kaya ang effect niyan, pag merge kay C, extinguish lang siya to the extent of 1/3. Hanggang 30 lang. Kaya yung balancing 60,000, pwedeng ma-enforce ni C as against A and B, based on original obligation. Enforcement ng original obligation yan. Kasi ang na-extinguish lang sa 90 is only 30,000. Pero let us modify. Punta tayo pagdating sa solidary. A, B, C are solidary liable kay D for 90,000. Si D inassign kay E. Then E back to C. Ang problema, since they are solidary debtor, pagbalik kay C, nag-merge dito, C can represent AB, that's why the entire obligation is extinguished. Totally extinguished siya. Pero without prejudice on the part of C, na pwede siyang mag-recover kay A and B ng right for reimbursement na 30-30. Baka tanungin mo, sir, parehas lang siya, di ba? Hindi. Magkaiba siya. Kasi ito, makaka-recover si C kay A and B ng 30-30, hindi for right for reimbursement, but for enforcement ng original obligation. Pero dito makaka-recover si C kay A and B ng 30,000 each, not for enforcement ng original obligation but rather right of reimbursement. Sabi mo parehas nga lang, hindi. Dagdagan natin ng facts. Paano kung si A dito insolvent? Kung insolvent si A at joint debtor to, wala kang makokole kay A. How about kay B? Yung 30,000 na share niya. Kasi walang pakialam si B sa insolvency ni A. Ikaw mag-suffered ng loss. Pero kung solidary debtor siya, insolvency A, okay, wala kang ma-recover kay A. Kay B, makaka-recover ka ng share niyang 30 plus yung 30,000 na share ni A, i-divide ng 2 yan. Kaya tig 15 si B6. Kaya makaka-recover si C kay B ng 30,000 na share niya plus 15 which is 45,000. Kaya magkaiba siya. Okay, now punta naman tayo sa another mode of extinguishment which is compensation. Sabi nito, definition, when two persons down in their own right are creditors and debtor of each other, there is what we call compensation. Now, what are the distinction between compensation versus confusion? Now, in compensation, there are two persons involved. Okay? Kasi these two persons in their own right are principal, debtor, and creditor with each other. But in confusion, there is only one person, wherein yung character ng debtor and creditor nag-merge on the same person. Second, sa compensation, there are two obligations. Sa confusion, one obligation lang. And last, sa compensation, may tinatawag na indirect payment. Kasi instead na bayaran kita, bayaran mo ko, let us offset. But in confusion or merger of right, merong tinatawag na impossibility of payment. Kasi how can the debtor pay the creditor wherein the debtor and creditor are the same person? Iisa lang sila. Kung baga nag-transferred ka lang ng money from one pocket to another pocket. Okay, now let us proceed now sa kind of compensation. As to effect or extent, pwedeng total. Both obligation daw are of the same amount. Halimbawa, I am indebted to you for 10,000, you're indebted to me for 10,000. Okay, total siya. I am indebted to you for 10,000, you're indebted to me for 8,000 lang, partial siya. Because two obligation are of different amount. Next, as to cause or origin, pwede raw siyang legal, voluntary, judicial, facultative. Pag legal, it takes place by operation of law. In fact, sabi ng batas, sa legal compensation, okay, magkakaroon daw ng automatic legal compensation by operation of the law, okay, when all the requisites for legal compensation are present, even though the parties are not aware of it. Kaya pag itong lahat ng requisite na to present, okay, even though the parties are not aware of it, magkakaroon siya ng automatic offsetting by operation of law. Voluntary naman is by agreement. O example, I am indebted to you for 10,000 due today, you're indebted to me 10,000 due next month. Hindi siya pwedeng illegal compensation because both debt are not yet due. Pero if the contracting parties agree to offset it, okay, even though meron siyang different period, then we call it a voluntary compensation. Judicial naman, it takes place by order from a court in litigation. Okay, sabi diyan, if one of the parties to a suit over an obligation has claimed for damages against the other, the former daw may set it off by proving his right to said damages and amount thereof. Example lang, halimbawa nag-file ako ng case sa'yo for collection of sum of money for 1 million. Okay, yung dependent naman nag-answer. Okay, sabi niya, yes, I am liable for 1 million pero may counterclaim siyang damages na 500,000. If during trial na prove for instance nitong dependent na entitled siya for damages of 500,000 and later on the court render judgment ordering the defendant only to pay the 500,000, then we call it a judicial compensation kasi nagkaroon ng offsetting through court order. Facultative naman can be set up only by one of the parties. Ibig sabihin pag isa lang party ang pwedeng mag-set up ng compensation, we call it facultative. Example lang. I am indebted to you for 50,000 due today. You're indebted to me 50,000 due next month pero nakalagay on or before. Ang tanong, can I offset? The answer is no kasi wala naman sa akin yung benefit ng period. Pero ikaw, pwede ka mag-offset kasi sa'yo on or before siya. Kaya ang tawag dyan, facultative compensation because only one party can set up compensation. Pero ito, hindi yan masyadong tinatanong. Ito lagi natatanong sa board exam. Meron tayong 4 na instances na hindi raw kayo pwedeng mag-offset. Pag ang obligation mo ay galing sa contract of comodatum, contract okay, of deposit, legal support, at obligation arising from a criminal offense. Kaya halimbawa, kung obligation ko sa iyo galing sa simple loan or mutuum, Ikaw ang obligation mo sa akin galing sa contract of comodatum. Ako lang ang pwedeng mag-offset, hindi ka pwede. Kasi ang obligation mo galing sa comodatum, ako galing sa mutuo. Facultative din siya. Okay, now punta tayo sa requisite ng legal compensation. Okay, sabi nga ng Supreme Court, okay, pag lahat daw ng requisite ng legal compensation are present, magkakaroon daw ng legal compensation by operation of the law, even though the parties are not aware of it. Anong first requirement? That each one of the obligor be bound principally and that him the same time as principal creditor of the other. Example, I am indebted to you for 10,000. You're indebted to me for 10,000. O, check number 1. I am indebted to you for 10,000. You are indebted to my guarantor for 10,000. O, absent ang requirement 1. Because they are not principal debtor and creditor with each other. Pangalawa, that both debt consist in a sum of money. If the thing due are consumable, they have the same kind and also the same quality if the latter has been stated. Halimbawa, I am indebted to you for 10,000. You're indebted to me for 10,000. Check number 2. I am liable to deliver to you 10,000 sacks of rice. Ikaw rin may obligation sa akin mag-deliver ng 10,000 sacks of rice, same kind and quality. Check number 2. My obligation to you is 10,000 sacks of rice. Your obligation to me is 10,000 sacks of sugar. Absent ang requirement 2. Number 3, that the two debt be due. Example, I am liable to you for 10,000 due today. Your obligation to me is 10,000 due also today. Check number 3. My obligation to you is 10,000 due today. Your obligation to me is 10,000 due next month. Absent ang requirement 3. Number 4, that they be liquidated and demandable. O example, question muna, lahat ba ng due ay demandable? And second question, lahat ba ng demandable ay due? Alin doon ang correct statement? Answer, okay, yung first statement is not correct. Hindi lahat ng due ay demandable. Sabi mo, example, sir. Example, my obligation to you is 100,000 due today. Your obligation to me is 100,000 due 10 years ago. Are both debt due? Yes. But both debt are no longer demandable because one is already prescribed. In fact, yung isa nga overdue na. Overdue. Kaya lumalabas, prescribed na, hindi na siya demandable. Kaya yun, okay, hindi pwedeng legal compensation doon. Kasi, okay, yung obligation, hindi na, okay, demandable yung isa. Pero lahat ng demandable ay due. Kasi bago ka maging demandable, dapat due ka muna. Pero hindi lahat ng due ay demandable kasi possible na yung isa ay already prescribed. And number 5, that over neither of them there be any retention or controversy commenced by third persons and communicated in due time to the debtor. Example lang, my obligation to you is to deliver 10,000 sacks of rice. Your obligation to me is to deliver 10,000 sacks of rice. Di okay na sana. Kasi yung 10,000 sacks of rice ko, may nag-claim na ownership si X as stranger at na-communicate in due time to sa party. Ang effect niyan is that, okay, hindi na siya pwedeng i-offset kasi meron ng, okay, controversy na create yung third person. And communicated in due time daw to the debtor. Okay, question muna. I am the taxpayer, kunwari government ka. Yung taxpayer liable sa government to pay taxes at yung government naman may obligation kunwari doon sa taxpayer. Ang question is that can we offset? Okay, the answer is no as a rule. Why? Because, okay, the obligation to pay taxes is an obligation arising from law. On the other hand, yung obligation ng government sa taxpayer is an obligation arising from contractual obligation. Second, when the government impose taxes, they are exercising in their sovereign capacity. On the other hand, when the government incurred obligation, they are exercising in their proprietary capacity. And next, the government and the taxpayer are not principal debtor and creditor with each other. That's why, as a rule, compensation is not proper. Pero may exception. Kasi kung halimbawa, lahat ng requisite ng legal compensation are present, pwede pa rin magkaroon ng legal compensation by operation of the law, even though the parties are not aware of it. Especially kung ang claim ng taxpayer against the government is already liquidated and demandable. Like may appropriation na to, okay, meron ng appropriation under the law. Okay, pero syempre general rule is hindi siya pwedeng i-offset. Now, the parties may agree upon compensation daw, okay, of debt which are not yet due. Okay? Now, Kasi yan, party may agree upon compensation of debt which are not due. I'm referring to what we call a conventional compensation. Okay. Wait lang. Sige, no sound. Okay, okay. Now, okay. Let us proceed now dito sa Article 1284. Sabi dito, when one or both debt are rescissible or voidable, they may be compensated raw against each other before they are judicially rescinded or avoided. Okay, example Okay, si A liable kay B for 100,000, pero si B nag-employed ng fraud. Si B naman liable kay A for 100,000, pero si A nag-employ ng violence. Ang question is that, pwede ba siyang i-offset? The answer of course is yes. Kung wala pang wala pang judgment for annulment. Okay, why? Kasi voidable contract lang siya. Di ba ang sabi ng batas, when one or both, ibig sabihin pwedeng one, ang defective isa lang, or pwedeng both, defective dito, defective rin. Either rescissible, voidable, or rescissible, voidable to. Okay, pwede mo pa rin siyang i-offset. Okay? Kaya nakalagay dyan, rescissible or voidable, they may be compensated against each other before they are judicially rescinded. Bago magkaroon ng judicial declaration ng rescission or annulment. Kasi ang reason dito is that rescissible contract are valid until rescinded and voidable contract are valid until annulled. Kaya meron siyang force and effect of law hanggat walang rescission o kaya walang annulment. Okay, pero kung halimbawa ito rescissible, unenforceable to, ay hindi pwede. Kasi pag unenforceable, di ba, valid siya but it cannot be enforced. Unlike pag rescissible sa voidable, meron siyang force and effect of law hanggat walang rescission or kaya walang annulment. Okay? Kaya pwedeng rescissible, pwedeng voidable, isang rescissible, pwedeng rescissible, perfectly valid, voidable, perfectly valid. Pero kung rescissible, unenforceable, hindi siya pwede. O kaya isang rescissible, isang void, hindi rin pwede kasi non-existing. Now, compensation daw takes place by operation of law, even though the debt may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. By the way, yung 1286 actually, halimbawa, ako debtor, creditor ka. Okay? My obligation to you is to deliver 10,000 sacks of rice from Manila to Quezon City lang. Ikaw naman may obligation ka mag-deliver sa akin ng 10,000 sacks of rice from Quezon City to Davao City. Siyempre, obvious na mas mahal ang transportation cost from Quezon City papuntang Davao City kesa dun sa transportation cost from Manila to Quezon City lang. Now, in that case, sabi ng batas, yung principal obligation offset pa rin. Pero magkakaroon kayo ng indemnity for expenses of exchange or transportation to the place of payment. Kaya kung may difference yung transportation cost, magbayaran kayo ng difference, pero yung principal obligation to deliver 10,000 sacks of rice is now extinguished. Ano naman yung 1289? Actually, yung 1289 is a combination of compensation saka application for payment. Combination siya. Kaya halimbawa, meron akong obligation sa iyo kunwaring 10,000. Okay, ikaw may obligation ka sa aking 10,000. Lahat ito due and demandable. Pwede kong i-apply yan either sa first, second, third, fourth, or fifth. Doon natin siya i-offset. Okay, pero take note, paki-observe nyo na lang yung rules ng application of payment. Kasi baka mamaya, yung isa hindi pa pala due, hindi mo siya pwedeng i-offset to. Okay, hindi siya same kind and quality, hindi mo na siya pwedeng i-offset. Okay, yan yung 1289. Combination lang to ng compensation sa application of payment. Okay, now may binanggit ako sa inyo kanina na may 4 na instances na hindi kayo pwedeng mag-offset. Pag ang obligation nyo ay galing sa contract of comodatum, contract of deposit, legal support, saka obligation arising from a criminal offense. Okay, example class si A, Nag-borrow kay B ng 100,000. That's why ang obligation ni A kay B is arising from a simple loan. Si B borrow from A 100,000, pero ang agreement nila, ibabalik ni B kay A yung 100,000 with the same serial number. Kaya lumalabas ang obligation ni B to return ay galing sa contract of comodatum. Kasi pag comodatum po anong hiniram, yun ang dapat ibalik. Now, ang tanong, pwede bang mag-offset si B? The answer is no. Kasi ang obligation ni B, comodatum, pero si A pwedeng mag-offset kasi ang obligation niya ay galing sa mutuum lang. Kaya ang tawag dyan, facultative compensation. Another example. Okay, si A, nag-borrow kay B ng 100,000, kaya ang obligation ni A kay B is arising from loan. Pero si A, nag-deposit siya kay B ng 100,000 for safekeeping. That's why the duty of B to return kay A 100,000 is arising from a contract of deposit. Can B offset? The answer is no. But A can offset because A, the obligation of A is arising from simple loan. B cannot offset because his obligation is arising from a contract of deposit. Okay, another, wife, husband. The wife borrow from the husband 100,000. That's why the obligation of wife, okay, to the husband is arising from loan. Yung husband naman, okay, nag-borrow, okay, sorry. Di ba may utang ang wife, mayroon siyang obligation kay husband to pay arising from loan. Later on, the wife filed a case against the husband for legal support and the court rendered judgment ordering the husband to pay the wife 400,000 for legal support. Ang question, can the husband offset? No. Kasi ang husband, ang kanyang obligation arising from legal support, pero ang wife pwede siyang mag-offset kasi ang obligation niya arising from simple loan lang. Another example, A borrow kay B 100,000, that's why the obligation of A to B is arising from loan. Pero si B naman ninakaw yung 100,000 ni A, kaya ang obligation ni B to return is arising from a criminal offense. Civil obligation arising from a criminal offense. Pwede bang sabihin ni B na hindi ko nababalik yung ninakaw ko kasi may utang ka rin sa akin? No. B cannot offset. Pero pwedeng mag-offset si A kasi siya mutuum, eto galing sa criminal offense. Pero by the way, kung halimbawa ang obligation ni A kay B comodatum, obligation ni B dito deposit, walang pwedeng mag-offset kasi pareha silang prohibited to offset. Paki-check nyo na lang siya sa problem. Okay, now punta tayo sa last mode of extinguishment. Okay, yung novation. Sabi ng 1291, obligation may be motivated by, okay, number 1, changing the object or principal condition, or by substituting the person of debtor or subrogating a third person in right of creditor. Pag pinaltan mo yung object or principal condition, ang tawag dyan is real novation. Pag pinaltan mo yung debtor, personal. Pag pinaltan si creditor, personal din. Okay, wait lang. Mga 1 minute. Okay. Okay, tingnan nyo to. Ito yung debtor, ito yung creditor. Okay? Ito yung object or principal condition. Pag pinaltan nyo yung object or principal condition, real or objective novation. Pero pag pinaltan ko yung debtor, or pinaltan ko yung creditor, ang tawag dyan, personal novation. Okay? Pag pinaltan ko yung debtor at the same time yung object or principal condition, we call it mixed. O kaya pinaltan ko yung object or principal condition at the same time creditor, mixed pa rin siya. Pero take note, kung pinaltan ko yung object, pinaltan ko yung principal condition, hindi siya mixed. Real pa rin siya. Kasi para maging mixed novation to, it must be a combination of both real and personal novations. O ngayon, tingnan nyo ha, pag pinaltan nyo ang debtor, ang tawag sa batas ay substitution. At ang substitution, pwede siyang expromission or pwede siyang delegasyon. Okay? Pero pag pinaltan mo ang creditor, ang tawag sa batas hindi substitution, but rather we called it subrogation. And it can either be legal or pwede siyang conventional. Okay? Itandaan nyo, pag pinaltan si debtor, substitution. Pag pinaltan si creditor, subrogation. Okay? Ngayon, kind of novation as to origin, pwede raw siyang legal. It takes place by operation of law. Okay? And these are not presumed. Ibig sabihin, hindi raw presumed to. Kailangan may batas na nagsasabi that there is novation. Pero pag conventional, okay, may agreement ng parties to. It must be clearly established daw in order that it may take effect. Conventional subrogation of a third person requires the consent of original parties and third persons. Now, since anong pinag-usapan natin dito? Yung conventional subrogation, di ba pag subrogation, ang pinapalitan creditor? O, balik tayo dito ha. Halimbawa, meron dito class na ito yung debtor, ito yung creditor. Meron ditong stranger, third person. Nag-usap tong tatlo, yung debtor, creditor, saka stranger. Napapalitan ko yung creditor. O, ang tawag dyan, conventional subrogation. Kasi di ba ang pinalitan creditor, subrogation yun. Pero since may agreement sa all parties, we called it conventional. How it is constituted? Pwede raw siyang express or implied. Pag express, it must be declared in unequivocal term. Kailangan may express agreement na yung old obligation extinguished by creating a new one. Example, may obligation to use to deliver a car. Okay, specific car. Later on, nag-enter din ang agreement that I will deliver to a specific truck. Ang question, meron bang novation? The answer is no. Kasi wala naman agreement na yung old obligation to deliver a car extinguished by creating a new object to deliver a truck. Okay, independent to. Dalawang obligation mo. Mag-deliver ka ng car, mag-deliver ka ng truck. Pero pag implied, wala kayong express agreement na yung old obligation extinguished by creating a new one. However, the old and the new obligation in all respect are totally incompatible with each other. Example, okay, halimbawa ang obligation ko mag-construct ng house dito sa parcel of land na to. And the land will be fully utilized. Okay? Tapos nagkaroon tayo ng another agreement later on that I will construct an apartment on the same parcel of land. Pero wala tayong express stipulation, di ba, na yung old object na mag-construct ng house extinguished by creating a new object to construct an apartment. Ang tanong, meron bang novation? The answer is yes, implied siya. Why? Kasi the old and the new obligation in all respect are totally incompatible with each other. Kasi hindi ka pwedeng mag-construct ng apartment at the same time, ng house at the same time, apartment on the same parcel of land. That is physically impossible. Kaya yung agreement natin na mag-construct ng apartment, impliedly novated niya yung old object na mag-construct ng house. Next, as to extent or effect, pwede raw siyang total or extinctive or pwede siyang partial or modificatory. Pag total or extinctive, it means we totally extinguish the old by creating a new obligation. Pero pag partial or modificatory, we don't extinguish the old, we simply modify it. By the way, pag halimbawa tinanong kayo ng ganito, okay, which of the following is not really a mode of extinguishment of obligation? Letter A, payment or performance. Letter B, okay, compensation. Letter C is condonation or remission of debt. And letter D is novation. Ang isagot mo, novation. Kasi pag in-analyze mong maigi ang novation, wala naman talagang mode of extinguishment yan. Talaga namang hindi siya na-extinguish. Kaya sometimes, di ba, ang tawag pagdating sa novation is modification of the old term. Kaya hindi mo naman talaga ini-extinguish yung old. Minomodify mo lang yung old term. Either pinapalitan yung object or principal condition or pwedeng substitution ka ng debtor or by subrogating a third person in place of creditor. Pero since ang question nga, which of the following is not really a mode of extinguishment, it should be novation. Okay, now kind of novation as to subject, pwedeng real or objective. Pag pinaltan mo nga yung object or principal condition, real yun. Pero pag pinaltan mo yung debtor or creditor, then we call it personal or subjective novation. Kaya pag pinaltan mo yung debtor, I repeat, substitution. Pwede siyang expromission or pwede siyang delegasyon. Ngayon, anong pinagkaiba ng expromission sa delegasyon? At paano ko ma-identify whether that is an expromission or that is a delegation? Simple lang. alamin mo lang kung sino ang nag-initiate ng substitution. Halimbawa, debtor to, creditor to, merong third person. Yung third person nag-propose kay creditor, sabi niya, Mr. Creditor, I have a proposal. Let us extinguish the obligation of the debtor by creating a new debtor. Ako yun, sabi niya. Kaya ito yung nag-initiate ng substitution. Pag pumayag yung creditor sa proposal ng third person, there is an expromission. Now, question, required ba ang consent ng debtor? No. Hindi kailangan ang consent ng debtor. Pwede siyang with or without consent ng debtor. Pero ang consent ng creditor, mandatory. Kasi pag hindi pumayag ang creditor sa proposal ng stranger or third person, there is no expromission. Kaya sa expromission, ang may consent lang yung third person saka yung creditor. Ngayon, ang tanong is this. What if nagkaroon ng substitution? Inaccept ng creditor ang proposal nito. Yun pala yung third person insolvent. Kaya hindi makakakolek ang creditor dito. Ang question, pwede bang habulin ng creditor yung original debtor? The answer is no. Kasi sa expromission, okay, walang revival ng obligation. In fact, wala tong consent ng debtor. Diba? Walang consent ng debtor dyan. Na-extinguish na yung obligation ng debtor dito by creating a new debtor. Kaya walang revival ng obligation. How about doon sa delegasyon? Okay, sa delegasyon naman, ang nag-initiate ng substitution yung debtor. Bawa, debtor, creditor, third person to. Nag-propose yung debtor kay creditor. Sabi niya, Mr. Creditor, I have a proposal. Let us extinguish my obligation by creating a new debtor. Ito yun. And all of them agree. Kaya mapapansin mo sa delegasyon, lahat ng parties may consent. Yung debtor, original debtor, yung creditor, saka yung new debtor. Now, ang question dito is this. What if a third person is insolvent? Di makakolekta yung creditor kay third person? Is the original obligation ng debtor revived? Pwede bang habulin ng creditor yung debtor? Answer, okay, general rule is no pa rin. Why? Kasi nga yung obligation ng debtor extinguished na by creating a new debtor. Okay, pero by way of exception, in order to avoid possible commission of fraud, magkakaroon ng revival ng obligation if, take note, magkakaroon ng revival ng obligation if at the time of substitution, may knowledge yung debtor na ito insolvent na. Or even without knowledge, pero yung insolvency daw nito ay already existing and of public knowledge na. Doon lang magkakaroon ng revival ng obligation. Kasi ang reason dito para ma-avoid yung possible commission of fraud. Kasi pwedeng magkaroon ng connivance between the debtor and third person. Kaya nga pag binasa mo yung batas doon sa Article 1295, sabi dyan, the insolvency of the new debtor was been proposed by original debtor and accepted by creditor shall not revive, o diba, not revive the action of the latter against the original obligor, except when said of insolvency was already existing and public knowledge na or known to the debtor when he delegated his debts. Kaya general rule, even in delegation, walang revival of obligation. Meron nga lang siyang exception. Pag may knowledge siya ng insolvency at the time of substitution or even without knowledge, pero yung insolvency nga ng third person is already existing and of public knowledge. Subrogation naman, third person is subrogated raw in the right of creditor. Mix naman, the combination ng real and personal novation. Okay, punta tayo dito sa other terminology. Creditor, original debtor, new debtor. Ang other term sa creditor is delegataryo. Original debtor is delegante, and the new debtor is the delegado. Okay, some illustration of novation as to cost or consideration, upward change the price. Halimbawa, ang original price is 1 million. Subsequently, in-increase nyo ng 1.2 million. That is novation. Next, principal terms and condition, debt subject to condition is made absolute one without condition. Halimbawa, original agreement ninyo may suspensive condition. Subsequently, nag-enter kayo ng new agreement, tinanggal yung condition, ginawang pure. That is novation. Case of Macondry versus Orwis. Reduction of term or period originally stipulated. Diba? Original term is 10 years. Then, subsequently, dinecrease ninyo ng 5 years. That is novation. Pero ang original term is 5 years, ginawa niyong 10 years, extension of period siya. There is no novation in one case. Capital stock of corporation is increased without the consent of some subscriber. Novation is never presumed kasi sabi ko, dalawa lang ang paraan para magkaroon ng novation. Either express or pwedeng implied. Sabi ko nga, pag express, it must be declared in unequivocal term. Pag implied naman, okay, yung old and new obligation in all respect are totally incompatible with each other. Kaya ang test natin kung may novation is this. Is the old and new obligation having an independent existence? Meaning pwede ba mag-exist yung old and new? Pag ang sagot mo is yes, walang novation kasi compatible. Pero kung negative siya, yung old and new hindi pwedeng mag-exist. Incompatible yan. There is novation. Okay, now what are the distinction between conventional subrogation and assignment of credit? Illustration muna. Sa conventional ba, the debtor, creditor, may stranger. Nag-usap yung tatlo, okay, papaltan ng third person yung creditor. There is novation. Conventional, subrogation. Pero kung halimbawa, sa assignment of credit, si D, ito si C, tapos merong third person dito, transfer ni C ang right niya sa third person. Assignment of credit yun. Okay? Kaya mapapansin mo dito sa conventional subrogation, okay, ang unang distinction, nagkaroon ng extinguishment ng obligation. Kasi papalitan dito ng third person yung right ng creditor. Ito walang extinguishment, transfer of right lang. Pangalawa, sa conventional subrogation, kailangan may consent ng debtor. Kasi may consent dapat yung debtor, old creditor, and new creditor. But in assignment of credit, okay, hindi required ang consent ng debtor. In fact, tandaan mo na lang yung receivable assignment. Sa receivable assignment, pwede ngang notification or non-notification basis pa nga, di ba? Kaya mere notification to the debtor, sufficient na. And last, sa conventional subrogation kasi, pag halimbawa, yung original obligation is voidable, o tapos nagkaroon ng okay, conventional subrogation by agreement, o magiging perfectly valid siya kasi yung defect dyan na-cured. Pero dito, kung voidable yung original obligation between debtor creditor, pag transfer ng creditor sa stranger dyan, voidable pa rin siya. Kasi ang rule natin sa assignment, the transferee cannot acquire better title than the transferor. Kung ang title ng transferor defective, ang title ng transferee defective pa rin. Some rules on novation. If the original obligation is void, the new obligation is likewise void. Reason, you cannot novate a non-existing obligation. Hindi mo pwedeng innovate to non-existing thing. Baba, ang original obligation natin is the debtor is obliged to deliver 10 kilograms of shabu. Edi void. Later on, nagkaroon ng agreement na hindi ka na magdi-deliver ng 10 kilograms of shabu but instead 100,000 sacks of rice. Void pa rin siya. Kasi nga, pag novation, di ba, modification of the old term. And then, since non-existing yung old obligation, wala kang i-modify. Second, pag ang original obligation natin ay subject sa suspensive or resolutory condition, yung new obligation daw ay subject rin sa suspensive or resolutory condition in the absence of any contrary stipulation. Example, my obligation here is to deliver a car, specific car, okay, if you pass the board exam. Later on, nag-enter din ang agreement that I will no longer deliver a car, but instead I will deliver a truck. Pero walang minention regarding passing the board exam. Ang tanong, subject pa rin ba siya to pass the board exam? Yes, in the absence of any contrary stipulation. Number 3, if the original obligation is voidable daw, then the new obligation becomes perfectly valid because the defect here is now cured. At pang-apat, if the new obligation is void, then you go back to the old. Kasi pag void yung new, hindi ko na-modify yung old. Kaya babalik ka lang sa original term. Unless daw may express agreement na yung old obligation is now extinguished regardless of any circumstances. Kaya yan lang exception natin. Okay, unless the parties intended that the former relation should be extinguished in any event of. Now, okay, presumption of legal subrogation. Di ba sabi ko kanina, okay, sa legal subrogation, it's never presumed. Kailangan may batas na nagsasabi na may legal subrogation. At ito yon, Article 1302. Una, when a creditor pay another creditor who is preferred even without the debtor's knowledge. Example lang. The debtor is indebted to the creditor for 1 million secured by real estate mortgage. But the debtor is also indebted to the creditor number 2 for 1 million pero unsecured. If creditor number 2, binayaran niya si creditor number 1 ng 1 million, even without the consent ng debtor, the creditor 2 will subrogate to the right of creditor 1. Kaya entitled na siya sa mortgage. Kasi a creditor pay another creditor who is preferred. Okay, second, okay, when a third person not interested in the obligation daw pays with the express or tacit approval ng debtor. Okay, example, debtor, creditor, third person. Binayaran ng third person yung creditor with the consent ng debtor, whether express or implied, then the third person will subrogate to the right of creditor. Pero di man nare-recall nyo, pag ang payment ng third person dito, walang consent ng debtor, entitled ka lang for beneficial reimbursement lang. Pero pag ang payment dito with consent ng debtor, entitled ka for legal subrogation. Okay, at number 3, okay, when even without the knowledge of the debtor, a person interested in the fulfillment ng obligation pays without prejudice to the effect of confusion sa latter share. Example, debtor, creditor, ito guarantor. Alam mo kasi yung guarantor, surety, pledger, mortgagor, mga third person yan na interested in the fulfillment ng obligation. Kasi pag nag-default to, liable din sila. Kaya ito yung third person, binayaran daw to kahit walang consent ng debtor, magkakaroon ng legal subrogation. Pero without prejudice the effect of confusion as to the latter share na. Okay, kaya ang effect niyan is that subrogation to, legal. Okay, kasi third person to na may interest sa fulfillment ng obligation, binayaran to. Okay, problem, ito yung 1304. Ito yung tinatawag nating class na partial novation. Ang sinasabi lang ng 1304, between the original creditor and a third person was subrogating his right, preferred pa rin ng original creditor. Okay, example, tingnan mo to. A daw owes B. May utang daw si A kay B. Okay, 10,000. Tapos si C, a stranger, binayaran daw si B ng 5,000 pero with consent ni A. Eh di syempre magsusubrogate si C, okay, kay B ng 5,000. Kaya technically, si A may utang kay B 5,000, si A may utang kay C na 5,000. Pero suppose daw si A daw may 5,000 lang, sinong preferred between B, C? O sinasabi ng 1304, between the original creditor and a third person who subrogating his right, preferred pa rin ng original creditor. Kaya dito, ang lalabas na sagot is letter D. B should be preferred. Kaya sabi nga ng 1304, a creditor to whom partial payment has been made may exercise his right for the remainder, and he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. Okay? Now, okay, itong multiple choice, okay, sa separate, ano natin to. Okay?